The Experts Forum on Policing did not specifically put together recommendations, so it's been left to me to glean the recommendations from the excellent discussion that took place. But there are three concepts that guided the discussion that are worth this session considering. They are the importance of context, the importance of specificity, and the importance of flexibility in dealing with policing and in dealing with legal remedies. And let me try to apply those to the various areas of concern and recommendation by our experts. First, attention was drawn to the importance of international instruments in combating anti-Semitism and the key role that parliamentarians have played, continue to play, and can in the future play in expanding the list of nations who are signatories to those international instruments. But again, in line with the concept of context and specificity, it is important to understand the gap between words and deeds that often accompany accession to international instruments, such that in many cases it is the countries that least need the assistance of the international instruments who are the most assiduous compliers with their obligations, while those who may need far more to pay attention to those international instruments find that though they may commit, they do not fulfill. Specifically in that regard, the experts thought that it was necessary to urge all signatories actually to monitor examples of racism and anti-Semitism that they have committed to monitor, and those who do monitor should be reminded of their obligation to report, because we heard that despite the fact that many nations accede to these conventions, few monitor and fewer still report, and unfortunately even fewer comply with their obligation to monitor and to report on anti-Semitic incidents as opposed simply to discriminatory or racist incidents. The next important area that was brought to our attention was the importance of standardization, which you've heard before. Our experts wanted to emphasize that unless there is standardization of definitions and of measurements, then it is impossible to compare the state of racism and anti-Semitism in different countries. And the ability of the international community actually to benefit from the international instruments depends on the international community being given standard tools that are agreed to across the board. The next area that our experts focused on was improving the available tools for police, for prosecutors, and for the judiciary in dealing with anti-Semitism and anti-racism. And here the concept of context played a great role. It was emphasized that police especially, but also prosecutors and judiciary, needed to understand the context in which racism and anti-Semitism occur. They need to understand these crimes from the point of view of those who suffer from those crimes. We were given an extraordinary explication by the chief of police of one of our largest districts, the York region, which is also one of the most multicultural and diverse areas in Canada, if not in the world, on how to accomplish policing through an empathetic connection with the community, and by learning how the community understands itself, understands the law, understands policing, and leveraging that understanding for constructive purposes. It was, in fact, suggested that hate crime be understood from the point of view of a victim as a crime that makes the victim less safe on account of a prohibited ground of discrimination, including gender, sexual orientation, race, religion, creed, ethnicity, nationality. I commend that to the parliamentarians for their consideration. Arising out of the concept of improved training comes the concept of specialization. It was pointed out that only specialized policing and prosecution services are able comprehensively to deal with the problem. It was also pointed out that the need for specialization far outstrips the availability of training internationally, and that an important area of focus internationally is providing tools for all jurisdictions to accomplish this sort of training. And again, in line with the concepts of context and specificity, much emphasis was put on the fact that the current global economic situation is a challenge that must be recognized and that nations must work to overcome it, so that budgetary constraints never become an excuse for lack of action. Finally, an important area that was explored was the need to re-examine legal and administrative remedies for racism and anti-Semitism. And again, in the spirit of context, we were reminded that different jurisdictions have different views about what constitutes protected speech, how far those protections go, and what legal remedies are available. And that, again, if we're going to be dealing with anti-Semitism in its specificity, we have to understand the legal traditions of the various jurisdictions and to work for remedies that make sense in those jurisdictions, rather than trying to impose a one-size-fits-all solution. Therefore, it's important, in the view of our experts, that we approach the problem of anti-Semitism and racism flexibly, considering a variety of remedies, including non-criminal law remedies, administrative law remedies, and other remedies. It was suggested by some of our experts that the concept of denunciation and the official nature of denunciation may be as important as the concept of punishment and retribution in dealing with anti-Semitism. And again, it was emphasized that anti-Semitism needs to be dealt with in its specificity as a unique manifestation, but also needs to be put within the context of racism and, where appropriate, to be dealt with on a platform of anti-racism. Finally, there was a great deal of emphasis on the importance of cooperation within jurisdictions, across jurisdictions, nationally and transnationally. Thank you.